This is Bloomberg Law with June Grasso from Bloomberg Radio.
Mr. President, do you plan to testify?
Yeah, I would testify, absolutely. It's a scam. It's a scam. That's not a trial. That's not a trial. That's a scam.
Donald Trump once vowed to take the witness stand in his hush money criminal trial. But the defense wrapped up its case this week without jurors hearing from the former president. Here's how Trump explained his reason for not testifying on WABC radio on Wednesday.
Yeah, because he made rulings that makes it very difficult to testify. Anything I did in the past, they can bring everything up. And you know what? I've had a great past, but anything. But the other thing is, and the main reason, and I don't even mind that. In fact, I like talking about it because we had rigged cases.
The jury has heard a month of dramatic and sometimes tawdry testimony from a tabloid publisher, a porn star, a longtime Trump aide, and his former fixer turned star witness as the prosecution tried to prove its case, charging Trump with 34 counts of falsifying business records. The defense put on 2 witnesses, but their case mainly consisted of cross-examining the prosecution's witnesses to poke holes in the case against Trump. Closing arguments are scheduled for Tuesday, followed by jury instructions, and then this Manhattan jury will begin deliberating whether Trump falsified his company's records to hide a hush money payment to porn star Stormy Daniels and influence the 2016 election. To get a conviction, the prosecution must convince all 12 jurors beyond a reasonable doubt that Trump falsified or caused the records to be falsified with the intent to commit or conceal another crime. Any verdict must be unanimous, but the defense only has to create doubt in the mind of one juror to get a mistrial. Joining me is criminal defense attorney Jeremy Saland. He was formerly a prosecutor in the Manhattan DA's office. Jeremy, let's start with the cross-examination of the prosecution's star witness, Michael Cohen. The defense attorney was very aggressive. How effective was he in undermining Cohen's credibility, which sort of hangs by a thread anyway?
I think that there was diminishing returns in the times that Blanche kept him on the stand. The lack of what I thought was enough leading questions as opposed to open-ending questions from what I read. And I also thought that there was times when he hit some of the same points over and over, and that goes back to the diminishing returns. And it's not just diminishing returns in that you lose the jury, they get the point, but you also run the risk of opening certain doors. The end of his cross-examination went flat. It could have been better, but at the same time, it exposed Michael Cohen for who he was, which is a conniving, dishonest, selfish person with an agenda to really hurt the former president. Now, I will say this, though, and this shouldn't be lost on anybody. When we think of John Gotti, I'm not comparing the two and saying Donald Trump is John Gotti, but who was the main cooperator in that case? It was Sammy the Bull. So when we hear about beating up Michael Cohen and we hear about the attacks on Michael Cohen, he's no Sammy the Bull. And if Sammy the Bull, who was alleged to have committed, I believe, 19-some-odd murders, could cooperate and have credibility and there could be a finding of guilt against John Gotti, for that matter, how many people loved the movie Goodfellas? That's based on Henry Hill. Henry Hill was a cooperator who had a rap sheet and all sorts of bad things. And people loved Henry Hill, or at least they loved Ray Liotta in the movie. So let's have some perspective here. You don't catch the main bad guy. You don't get the kingpin. You don't get the main drug dealer. You don't get the main mobster. Not saying, again, that that's who Donald Trump was, but you don't get him or her unless you get the person who is next in line, a lieutenant, a worker, the dealer, the guy who cuts the drugs, the guy who counts the money. You don't get that unless you have someone who has dirty hands. That's how you get the big boss.
The defense called 2 witnesses in their case. The last one was lawyer Bob Costello, who I think they called to damage Cohen's credibility even further, but he ended up acting out on the witness stand, being disrespectful to the judge, rolling his eyes, muttering on the stand. And at one point, it was incredible. The judge said to him, "Are you staring me down right now?" And the judge cleared the courtroom.
Really disappointing if I'm Donald Trump's team and Donald Trump, because you have a witness who objectively could have shared some really valuable information about Michael Cohen supposedly telling him that Donald Trump wasn't aware, that basically Donald Trump was not in the know on what was going on. But it was lost in the petulance, sophomoric, amateur behavior from a guy who served in his senior capacity at the U.S. Attorney's Office. This is not his first rodeo. What he was thinking, he shot his own credibility in the foot. Don't run your mouth. Show respect to the court. You may be a Fed and you look down on the state. Maybe that's a little of his arrogance. I don't know. But you're in a court of law, and follow the court's instructions. And as I tell every witness, kill him with kindness, look the defense or prosecution in the eyes, look the jury in the eyes, be respectful, be the bigger person. That's what he did not do. And I'm really surprised.
So the biggest news to come out of the trial this week was no news, actually. Trump had vowed to testify in his own defense, then started backing off. I don't know that any defense lawyer would have encouraged him to testify. So was that the right decision?
Unequivocally, absolutely. And any criminal defense attorney would say, especially in a case like this where he has a chance to hang. Do I think he's going to get an acquittal? No. But I'm going out on a limb here. I may be completely and totally wrong. If I could read juries, I would be charging a lot more. I think we all would. But none of us can read a jury's mind. But every New Yorker knows the term chutzpah. And he did not have the chutzpah to get up there. Despite his behavior and his demeanor, he would get eviscerated. He would get hung out to dry. And if he has a chance of beating this case, he would have lost it if he ran his mouth, because he would have opened up door after door. And as bad as Costello was, and as good, frankly, as Michael Cohen was, none of them, even on their worst day, would have done what Donald Trump would have potentially done on that stand. So it was a smart move, an intelligent move, common sense move not to get up and testify.
Looking at the prosecution's case, has the prosecution made out its case, do you think?
I thought the evidence went in pretty well. There is an element of common sense that is so critically important here. If I'm the prosecution, I'm arguing and saying, you have Weisselberg's handwriting on these notes. It's not just Michael Cohen. It's not just Stormy Daniels. You have phone logs. You have other witnesses. You have Hope Hicks, who puts people in certain places at certain times, who describes Michael Cohen not as a giving, generous person, that he's going to go out on a limb here. A man who I believe made roughly $500,000 a year and took a home equity line of credit out and was going to bear responsibility and take ownership of those dollars. That seems pretty unlikely. So I think very much that the evidence went in well. Will the jury convict? That's tough, but all they need is one, remember. All they need is one to hang in the defense.
Legally, the case gets complicated because the prosecution, as you know, is out to make these misdemeanors of falsifying business records into a felony. So it has to be done with the intent to commit another crime. How tricky is that for prosecutors?
It's tricky because a couple things. When the jury gets the case, a judge can instruct the jury on what's called a lesser included offense, meaning the judge can tell the jury, you can consider the felonies on the indictment. But even if you don't find the felony, you could find for the misdemeanor of that same falsifying business records. That's what's called the lesser included offense, even though it's not actually charged. Now, the question I would ask is, if I'm the prosecution, do I ask the judge not to submit that? If I'm the defense, do I ask the judge to submit it or not to submit it? Why do I ask that? Because in my view, a conviction on the misdemeanor is a loss, and that's egg on the face of Alvin Bragg. It's really all or nothing. So it's either a conviction on the felony or an acquittal. If I'm the defense, do I want to make the jury make that decision and don't give them the sort of compromise? It either is or it isn't. So it's an interesting question whether they're going to want the judge to instruct the jury or it's all or nothing. That's number one. The other difficulty is, what is that other crime? Now, you don't have to prove that crime beyond a reasonable doubt that you're trying to conceal, some election crime. So don't misconstrue that to prove this secondary element to make it the felony, the intent to commit or conceal this other crime, that you have to actually prove beyond a reasonable doubt that other crime. But, I didn't see as much strong evidence as you did about the actual direct evidence of falsifying business records or the circumstantial evidence. It was more difficult. So I see the misdemeanor as an easy conviction, frankly, from what they've done. The felony is going to be a little bit harder. I think they did a good job, but I think it's still going to be hard.
The jury instructions are always important. How much depends on how the judge frames the instructions for that second crime?
Well, there was some argument back and forth, if I recall, about whether there was two intents, and that's what the defense was asking for. It's the intent to defraud and deceive, and you have to have the intent to commit another crime. There's an expanded definition of intent, for example, that's in the actual jury instructions where there's a charge solely for intent as opposed to the intent you will find in the charge for the particular crime, which is the same across the board, which is basically it's your objective and goal. But there's an expanded version. So this is a complicated case, but it's not. It's fairly straightforward. And if the jury has problems, they can go back and ask for the judge to re-instruct them. They can go back and ask to hear the transcript again and to listen to testimony again. But framing it has to be done in the right way. I have confidence that the court will. I have zero worry about that. But people are people. This is an intelligent jury. These are New Yorkers. They could find reasonable doubt, I'm sure, and they could find proof beyond a reasonable doubt.
Has there been any real testimony or evidence on Trump's intent or motivation?
The prosecution does not have to prove motive. That is not an element of the crime. As much as we want to add that in, as prosecutors and defense attorneys may challenge or add their own motives, it's not a requirement. So, for example, if your motive was to protect your family, as the allegations were on the former president's side, as opposed to the prosecution allegation, which was to fix or protect the election, there is no requirement that that motive be proved beyond a reasonable doubt. I will say, however, if I'm the prosecution, I would say, even if you believe that that was his motive, that was to protect Melania, what I would say is they're not mutually exclusive. You can want to protect your family and have the intention of protecting your family, and there's the intent, not the motive, but he also had the intent to protect himself in the election and make sure this didn't get out, to protect the election. So it's a mixed bag. And in terms of the evidence coming in, this goes back to that common sense. This goes back to why are they paying for it? If you believe Trump had his hands in it, why is he paying for this at this time, right before the election is about to hit, as things were going sideways, and you have Hope Hicks telling you that, this could be really, really detrimental to women voters. I think they did the job they needed to do, even if not directly, because you don't hear from the Donald Trump, but circumstantially through all the other evidence and testimony. This is not easy, and, as much as all of us want to pontificate and say, I believe X or I believe Y, I'm not going out on a limb other than to say that I do believe the case went in well. I do believe that the prosecution proved their case. I don't think that Blanche and his team did the job they needed to do. Michael Cohen kept his composure up there. I thought they beat up Stormy Daniels a little too much. I do think that the defense, their main way I think they'll take this down or tear this apart is you can't believe Stormy Daniels. She's an extortionist blackmailer. And you can't believe, a guy who's a thieving, malicious, vengeful guy in Michael Cohen who's a known liar, and make it about the two of them as opposed to making it about falsifying business records. And the prosecution has to do their job and bring it solely back to falsifying business records.
Next week is going to be very interesting, and we may even get a jury verdict before the end of the week. Thanks so much, Jeremy. That's criminal defense attorney Jeremy Saland. I'm June Grasso, and you're listening to Bloomberg. By a 6-3 vote down ideological lines, the Supreme Court's conservatives upheld a Republican-drawn congressional map in South Carolina, rejecting a lower court's finding that lawmakers unconstitutionally relied on race when drawing the map. In the majority opinion, Justice Samuel Alito echoed the position he'd taken during the oral arguments, saying that challengers had not shown that race rather than partisan politics was the driving factor in drawing the map, and flat out rejecting the evidence the three-judge panel had found after trial.
At least as a practical matter, in a case in which there is no direct evidence or virtually no direct evidence, there is no way in which a plaintiff can disentangle race and politics except by providing an alternative map.
Justice Elena Kagan wrote a scathing dissent for the three liberals, saying the majority's decision signals that state legislators can now use race as a proxy to achieve partisan ends, as she told South Carolina's attorney.
You think, well, the evidence showed that we were just doing politics. And the court said, no, the evidence showed that you were doing race as a proxy for politics. And surely there were good reasons to do race as a proxy for politics here.
With this decision, the court is making it much more difficult for plaintiffs in the future to challenge maps based on racial discrimination. Joining me is election law expert Richard Briffault, a professor at Columbia Law School. Rich, explain Alito's reasoning in the majority opinion.
The majority concluded that the three-judge court below, the district court, erred, that there was clear error in finding that the redistricting of District 1 in South Carolina was done on the basis of race rather than on the basis of party. The court recognized that racial gerrymandering and partisan gerrymandering often look alike, and said the burden was on the plaintiffs to show that this was race and not party. And then the court then kind of carefully picked apart in quite detail the findings of the district court and concluded that the district court had made a mistake in concluding based on the evidence that this was racial rather than partisan.
I mean, the district court had heard evidence, right, and made these conclusions that the Republican lawmakers established a target of 17% black voters for the first district. Alito said the state had strong evidence that the 17% figure was simply a side effect of the legislature's partisan goal. What evidence is he talking about?
Well, the thing is, normally when you're reviewing a district court's findings of fact, the burden is on the state to show that the district court was completely wrong. And here he seems to have put the burden more on the plaintiffs, not just in the original case where they persuaded the district court, but also in the Supreme Court to show that the district court was right as opposed to being reasonable. I mean, in some ways, there's an argument that he, in applying what is theoretically a deferential standard to the district court, the standard of clearly erroneous, he went much further and, in some sense, reviewed all the facts himself and concluded that on his reading of the facts and his reading of the expert testimony, the plaintiffs had not made their case.
He also said that a party challenging a map's constitutionality must disentangle race and politics if it wishes to prove the legislature was motivated by race as opposed to partisanship. And the challengers provided no direct evidence of a racial gerrymander. Is he looking for a statement by a Republican lawmaker, oh, we're doing this because of race?
Right. I mean, he basically said you could either do it by direct evidence, like a smoking gun statement, or by strong circumstantial evidence. And here what the plaintiffs were able to show is if you look at the numbers, there was a huge movement of people in and out of this district. The map makers dramatically moved large numbers of people around. In particular, they seem to be moving more black voters out and more white voters in. And that in the end, with all of the movement, that 16.8% number was a number that the Republicans felt was low enough so that the district would continue to tilt Republican. His view is that was really about partisanship. The plaintiff's view and the district court's view was that, no, that showed that they were engaged in a racial gerrymander. They moved like 180,000 people around, but their target was to keep the racial fraction the same, and they did it by moving black voters in one direction and white voters in a different direction.
Justice Kagan wrote a blistering dissent for the three liberals. She said the majority was stacking the deck against the challengers by presuming legislatures are acting in good faith. Go right ahead, this court says to states today. It will be easy enough to cover your tracks in the end. Just raise a possibility of non-race-based decision-making, and it will be dispositive. And she quotes from Alito's opinion, taking him head on.
Yeah. I mean, Alito begins with the basic premise that whenever a law is challenged, the law is presumptively valid, the burden is on the plaintiffs to show that it's invalid. And that's a kind of Judicial Review 101, is you begin with a presumption of validity. But she's saying he's taking it so far that he's using it not at the opening stage of the case, but on the appeal following a determination by the district court after a lengthy trial with lots of testimony, lots of exhibits, lots of depositions, a three-judge panel that found the other way. And so she's saying that, in effect, he's putting such a heavy thumb on the scale for the legislature that he's making it almost impossible for plaintiffs to prevail in a case, even after they prevail before the district court.
Is this decision raising the bar for winning a challenge to a map based on racial gerrymandering?
I think it is. I mean, I think basically the burden is now even heavier on the plaintiffs to disentangle race from party and to show it was clearly race and not party, as opposed to the intertwining that we often see. So I do think, although technically he's applying the same standards as before, he is now applying them in a much tougher way. He's also added a kind of requirement that court had rejected as a requirement before, which is that the plaintiffs produce an alternative map, which produces the same partisan results, but with a different racial makeup, to show that it really was race and not party that was driving this. The court in the past had said having a map is helpful, but now he has come very close to making it a requirement.
It is difficult to separate race from politics. Mm-hmm. But does this give, as Elena Kagan said, state lawmakers an incentive to use race as a proxy to achieve partisan ends?
Yes, I think until now, the court has said that although we won't hear partisan gerrymandering cases, we will hear claims of racial gerrymandering. So it was one way in which plaintiffs couldn't directly attack the partisan gerrymander, but they could try and do that if they could show that it was also a racial gerrymander. Now the court has pretty much made that impossible, or made it in any event much, much harder to be able to make a racial gerrymandering claim outside the context of party. I suppose you could have a racial gerrymandering claim in a one-party state, but in a situation where race and party are so intertwined, it's going to be much harder to make any kind of racial gerrymandering claim.
So for anyone who thought that the conservatives had changed when the court ruled that Alabama Republicans violated the Voting Rights Act, is this proof that, no, it hasn't changed?
I think it shows the ongoing difficulty of dealing with these districting disputes when race and party are so intertwined. And yes, that case, the Alabama case, was a case where the court did defer to the findings of the lower court. And there, the plaintiffs did provide alternative maps to show that the districting could be done in a different way. But I think in some ways it really does show the court's kind of impatience with the effort to possibly outflank the court's unwillingness to hear partisan gerrymandering claims by hearing racial gerrymandering claims where if the plaintiffs win, the victory would be similar to a victory in a partisan gerrymandering case. I think they've just made that much harder, if not impossible.
We've been talking about the constitutional challenge to South Carolina's map based on the Equal Protection Clause. But didn't the challengers also bring a claim based on the Voting Rights Act?
They did bring a Voting Rights Act vote dilution claim, which they won on, but the court said the lower court erred on that as well because the lower court sort of applied the same standard. And it's a different standard for vote dilution cases, so they reversed and remanded. So if there's going to be a trial on that, it would be a different claim. I think they have somewhat different theories. The theory of the equal protection claim is that the state's motivation was predominantly racial. It doesn't have to show that there was an underrepresentation of black voters, but just that the state was purposely drawing lines based on race. Whereas vote dilution, you don't even have to show that race was intentional. What you do have to show is that as a result of the line drawing, black voters or voters of color were underrepresented, that it was more difficult for them to win elections than otherwise.
Would you say that for the last decade or so, the Roberts Court's decisions have made it harder for black voters to challenge redistricting plans?
Well, the Roberts Court obviously famously got rid of Section 5 of the Voting Rights Act, which required states in covered jurisdictions to get Justice Department approval first. So therefore, actually putting the burden on plaintiffs to go ahead. I think how they've handled vote dilution cases has been a little inconsistent. As you point out, plaintiffs won a vote dilution case from Alabama last year. This was technically a constitutional case, so it's a little hard to characterize. Sometimes plaintiffs have won, but certainly this one, I think, is going to make it much harder for plaintiffs to win cases like this.
As you know, the Republicans hold this razor-thin majority in the House, and the outcome of this case and other redistricting cases could help determine which party controls the House for the next decade. As far as the cases that have been decided so far, do the Republicans have an advantage now?
My understanding is that the Republicans have gained slightly through the redistricting process because of a partisan gerrymander they pushed through in North Carolina. After the North Carolina Supreme Court changed hands, North Carolina Supreme Court had struck down a Republican gerrymander in North Carolina, so the state was 7-6 Republican-Democrat. Once the North Carolina Supreme Court changed over, the legislature re-redistricted, and it's now going to be 10-3. So I think there was a big Republican pickup in North Carolina. The rest of the country, I think, is a little mixed. There may be a Democratic pickup in Alabama, maybe one in Louisiana as a result of redistricting. But North Carolina was a big win for the Republicans.
The Republicans were bold in North Carolina while the Democrats were timid in New York.
Not clear that New York is going to change, right? In the end, the new plan in New York tinkered very slightly with the districts in a very, very close election. That might make a difference. But the New York redistricting did not make big changes.
Yeah, it's puzzling why the Democrats even bothered with all the litigation. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next on the Bloomberg Law Show, why Google cut a check for the U.S. government, and will it work? I'm June Grasso, and you're listening to Bloomberg.
As alleged in our complaint, for 15 years, Google has pursued a course of anti-competitive conduct that has allowed it to halt the rise of rival technologies, manipulate auction mechanics to insulate itself from competition, and force advertisers and publishers to use its tools.
The Justice Department suit accusing Google of monopolizing the digital advertising market is scheduled to go to trial before a jury in September. But Google is trying to avoid trying the case to a jury with a novel move, cutting the government a check. The search giant wants a judge, not a jury, to decide the case, and argues the government has no right to a jury trial without a claim for money damages. Joining me to discuss this novel and perhaps futile move is antitrust law expert Harry First, a professor at NYU Law School. Harry, has this been done before, paying damages before a trial or a finding of liability?
Not to my knowledge. It's you might say a clever move, or you might say it's a silly move, or you might say, when it's Google, who cares how many millions of dollars you may pay unnecessarily? So I've never seen this before. Litigants don't usually pay out money in advance of a trial, in advance of even losing. So you got to have a lot of money to do that.
The Google argument is that without a monetary damages claim, the government has no right to a jury trial. Is that true?
Well, Google's argument is, let's see, should we call it silly, ridiculous, or desperate? I don't know. So if you are not asking for money, go back to day one, you file a complaint, and all you're asking for is an injunction. That is what's called a suit in equity, and is just handled by a judge. That's the way cases have been handled since common law period. If, on the other hand, you go into court and you ask for money damages, that has to be before a judge with, under the Seventh Amendment, if it's for more than $20, I think, with a jury. So that's the distinction. Now, what Google's trying to say is, oh, guess what? Now there's no damages, so you don't get the jury trial. So presumably the Justice Department will say to this check, thank you, but no thank you. We want to prove our damages, and we'll prove them anyway. So it is still a suit for damages, and you can't get out of it by sort of prepaying the damages and now saying, guess what? It's not for damages. The suit was always for damages.
The size of the payment hasn't been disclosed, but Google said that after months of discovery, the Justice Department could only point to estimated damages of less than $1 million. Since the law allows the court to issue treble damages, the speculation is that Google's check is for about $3 million, which is a drop in the bucket to Google.
Well, yeah. Originally they claimed at least $100 million, and what they're going to be able to prove up at trial, it seems to me, is still a question for trial. So I don't know what their expert reports show or whether they have some additional evidence. So I don't know what the amount is. And I think, frankly, it doesn't really matter. The legal point is the case was filed for damages. It is still a case for damages, and paying them off doesn't end the case and doesn't change the nature of the case. So I don't see this as the gambit that's going to work. Their claim is not moot, no matter how much the check's for. And you're right, from anyone's point of view, whether it's $5 million, $10 million, $100 million, this is not very much to Google, and that's really, frankly, not the point. So I think, more significant are the other arguments that Google tries to make, which is that this shouldn't be a suit tried by a jury, and that's a more straightforward argument. It's not, yes, it's a jury trial, but no, it's not a jury trial, because, it would sort of be like saying, well, you asked for an injunction, so, yeah, it's fine, we're fine with an injunction, so now it's not a case for anything. So I don't think that's going to work.
Google also argues that the government has said the case is highly technical and outside the everyday knowledge of most prospective jurors. Google said it's aware of no case in American history where a civil suit brought by the United States pressing only antitrust claims was tried to a jury.
It's likely that that's correct, simply because the Justice Department has almost never filed suit for damages. And so it's not a major claim. What would be an interesting claim is if nobody had ever filed for a jury trial, including private parties. And that actually is not true. And in fact, this claim was made in the 1980s in litigation involving the sale of Japanese televisions in the United States at allegedly predatory prices. And the defendant, Japanese television manufacturers, made a strong effort to say there is no right to a jury trial here because it's too complex. The courts never quite got to that holding for other reasons. They focused on other issues. But we've seen the claim before, and courts are not all that well disposed to it in private cases. There are lots of complicated cases, patent infringement cases, patents are complicated. A lot of patent infringement cases, a large part of it is tried to juries. Trade secret cases, complex fraud cases. There's a lot of complex cases. To say somehow antitrust is beyond the realm is a little silly, particularly after Google had a jury trial in the Epic case. Now, Google's right to say that this is unusual for the government, but that's a knock on the government, but not on the legal case. And there are reasons for that. But the government clearly has the statutory right to sue for treble damages. Congress gave that to them in 1990. Originally, it was single damages, 1955. I mean, it is a specific statute. So, as I said, frivolous, bad argument.
Harry, before we go any further, tell us about the government's case against Google here.
Basically, it involves the advertising side of what Google does and the auctions that it runs for those ads that you see popping up every time you move online that seem to say, "Hi, Harry, this is for you." You know, search advertising, display advertising. And they run auctions. I forget the number every second, but it's a huge volume of advertising auctions. And they run the platforms, and they provide the tools for both the advertisers and the publishers of these ads to figure out how much space there is, where these ads could go, what to charge, how to auction them off so that each side feels they're getting the best deal. And, you know, they sort of run the show, and they also have the search engine that generates, you know, a lot of the information. So they are all over what people call the ad tech space. And the Justice Department wants to separate out some of these functions so that different platforms might arise that could compete against Google without, you know, having the same search engine, having sort of the same tools that seem to favor Google and placement on Google websites rather than through Bing and so forth. So that's the real thumbnail sketch, but, you know, everything you read, the first thing, you know, that people say is, well, this is a complicated market to understand. But, you know, again, this is what good trial lawyers do. They break down complexity so that the people who have to decide the case, in this case the jury, can follow it through, and that's going to be their challenge.
You mentioned the Fortnite maker Epic Games case. That was one of the worst legal losses for Google. So Google's been burned by a jury. Is that why it may be looking for a judge to decide this case? Although I would think that it would be harder to try a case before an experienced trial judge than before a jury.
Your question now has moved from, are they making a frivolous legal argument, to, are they making a smart tactical argument? And, you know, I'm not sure the answer to that. Why do they prefer Judge Brinkema to a jury? And the only answer I can come up with is just what you said. They don't want to present themselves to a jury. They did that in Epic, which they wanted to avoid desperately and were unable to. And in less than 4 hours, the jury said, "We know who you are. You are a monopolist. You know, cut the fancy junk. You're a monopolist and you've excluded competitors." They didn't have much trouble with this. Now you could say, well, one strategy is you make this so complicated to the jury to just throw up their hands and say, "We can't figure this out." On the other hand, a jury trial is an incentive to both parties to present an understandable case. And, you know, the government chose this, and they actually chose a difficult path. They have the burden of proof, and they have to make this understandable to the jury. And it's not going to be easy, I don't think. It's a complicated industry. But, you know, if they do it well, the jury will understand it. And maybe that's exactly what Google's afraid of. The jury will see they're on both sides of these transactions. Even Microsoft, the second largest company in the United States by market cap, but valued over what now, $3 trillion or $2 trillion? I lose $1 trillion here or there. Even they are having trouble in this space. And, you know, I think jurors will get it. And I think Google's afraid that jurors will get it. And obviously, they're not so much afraid of the money part here, since they said, "Hey, here, take our money, please." They're worried that the jury is going to find against them that they've monopolized this market, and then strong relief is going to follow.
But if a jury would get it, wouldn't a judge get it as well and, you know, get it faster and with more background information?
I do wonder about that. Judge Brinkema is a really good district court judge, She's moved this case along pretty quickly. She doesn't seem disposed to Google's efforts to get out of her court. She hasn't dismissed the complaint. So I wonder why they think they'd have a better chance with her. When it comes to tactics, these are judgment calls. You know, those lawyers may know things about their case, may feel that she could understand better why they're on all sides of the transaction, how these marketplaces work. I don't know. That's a decision they have made, though. They really don't want 12 people judging their behavior.
Some of the plaintiff states that had joined the Justice Department suit said the court should deny Google's motion for summary judgment, allow the case to proceed to trial. Quote, Google argues that it lacks monopoly power along every dimension except the one that matters most under the law, whether it has the power to control price or output. And it does.
Well, you know, just as in the Epic litigation with Fortnite, yeah, don't look over here that we have a monopoly. Look over there that we compete for lots of other advertising and so forth. And a lot of this does turn on some sort of technical concepts about how we define markets and what the market share is. And the state's position is that we can figure out whether someone is a monopoly not just by defining a market and seeing whether they have most of it. We look and see whether they can do what monopolists do. So monopolists control price, they raise it, and they restrict output. And that's what they want to show in their case, that they control the output of advertising and these advertising services, and that leads to higher prices.
There's a hearing on June 1st before Judge Brinkema, and we should learn more then. Thanks so much, Harry. That's Professor Harry First of NYU Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.